When it comes to hospital bills, you either owe them or you don't. But you don't necessarily owe what they're telling you to pay. There are 3 ways to handle a hospital bill. The first is simply to pay them. Pay exactly what they say you owe, and please stop complaining about it. Or 2, you're not able to pay them, and they will take you to court to get a judgment to make you pay. They will confiscate your bank account, any assets you have, and if there is still a balance, they're going to garnish your income, all the while adding interest and fees until it is all paid in full, even your Social Security or disability, or until you're dead. And then they'll probably try and collect from your spouse, even your kids. You can tell them that $150 is too much for an aspirin. $2,500 a night is a ridiculous amount for even the most luxurious hotel. And a saline drip is only salt water, so they don't get to charge $200 for it. You either bow down and pay them, or they are taking you to court. Since you're going to court anyway, why not fight for a reasonable bill that you can actually pay and will not destroy your credit report? Your credit report determines your very ability to work, live, even eat, so you have the right, even the responsibility, to keep it working for your benefit. Some of you may believe that you have to pay whatever bill the hospital hands you because they had you sign a contract. Nope. Did that contract spell out each and every cost you were going to be charged? Did it say each aspirin tablet, $150, each nightly stay, $2,500, bathroom accessories, $75, and on and on and on? Or does it just say a general, you agree to pay any and all charges? Well, let me tell you about the any and all charges. It would be insane if they came to you and said, I want your firstborn child, right? Well, you agreed to any and all charges. So basically, you agreed to anything they want to charge you for anything they do to you. That is insane. No court in this land would hold you reasonably responsible for such a contract. When you signed that contract, were you in a hospital bed, on any medication, just brought in from an accident, or just had a medical emergency, a parent of a child just brought in? Well, that's called signing a contract under undue influence or duress, whichever way your local law sees it. And you cannot be held legally responsible for anything you've signed under duress or with undue influence. However, you have to actually stand up and defend yourself to defend yourself. The more often you stand up for yourself, the more invincible you become. If you're not just going to roll over, well, grab a pen because you're going to want to take notes. Here's what you can expect. First, you are going to want to see an itemized breakdown of the bill. It needs to show where every penny charged came from, what it was for. Okay? They have to give you this. If they don't give it to you, get it in writing. Then I want you to dive into the unusual charges like medicine, drips, hospital rooms, tests, toothbrush. Charges for doctors are too subjective to argue. They vary from doctor to doctor depending on their skills. But $150 for an aspirin is certainly outrageous. Find out exactly how much these products or services actually cost them. What did they pay for that bottle of aspirin that makes them need to charge so much for it? How did they determine an overnight stay should cost $2,500? But most important information of all, you want the salaries of the executives and the board of directors of that hospital. Now, if this hospital is a nonprofit, I want you to keep this in mind. Our government was the first nonprofit formed in this country, and nearly 250 years later, its highest paid executive only makes $250,000 a year. $250,000 a year. Now, if that's good enough for the first nonprofit to still be in existence almost 250 years later, then it's good enough for every other nonprofit. Nonprofits were never meant for their executives to make millions of dollars in salary. Keep that in mind. Get the evidence so you can show it to the judge if you do have to go to court. Then I want you to get as much evidence together as you can that will prove what state of mind you were in when you signed that contract. Were you just brought into the emergency room? Just brought in your child? Were you injured? Had they already given you medication? Were you worried about dying? Or someone you love dying? Did they tell you or lead you to believe that you either need to sign this contract or there would be no care? Those are called duress and undue influence, depending on your situation. You can't be held responsible for a contract that you signed under duress or because of undue influence. Now I want you to come up with a reasonable bill. Make them an offer they can't refuse. Okay, so my godfather is terrible, but what I'm saying is you're going to renegotiate a reasonable contract. Now, if they are negotiating with you, keep negotiating, but get it in writing. Never, ever, 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 ever take their word for it. If they absolutely refuse to work with you, you have two choices. One, either wait for them to take you to court for your past due bill, which they will do, and defend yourself with all of your evidence, or you file a complaint and take them to court yourself. Either way, you're going to end up in court. Worst case scenario, you go to court and they win. So you're just going to have to pay back the original bill. But with the judge's help, you will be able, even if you've lost, to negotiate a payment you can actually live with. You can even ask the judge to take away all interest, fees, and additional charges. You are in the right here. Nobody in their right mind would sign an open-ended, any charges contract. I'm not saying you're always going to win just because you're in the right. But I can guarantee you will never win if you never try. Here's what to expect if you take them to court. 1, the tools at your disposal. Magistrate court is a safe court. It is probably the highest court you will ever go into, but they are very used to working with pro se, people who represent themselves. If you don't believe me, take a day. Go sit in on your local magistrate court. You'll see how it flows, how the people talk to the judge, how the judge talks to the people, and you'll see. Every magistrate court website has a pro se handbook. That pro se handbook is the rules of their court. Follow them. Next, I want you to find your local law library. It is free and open to the public, and you will have access to every single tool a lawyer does. Not to mention, there are some amazing people that work there who love to help you with your cases, to help you find what you're looking for, to guide you in the right direction. You don't need to be an expert. Just learn your cases, your courthouse. Here are a couple of cases you might want to read up on regarding duress and undue influence. If you can't afford court fees, don't worry about it. All you'll do is fill out a form called an in forma pauperis. Simple form. Just fill it out, explain to the court why you can't pay them, and all fees associated with this case are paid by the court, even the cost of serving the summons. When it comes to the complaint, remember these simple rules. Keep it simple, stupid. If it is not a fact, do not put it in the complaint. A fact is something you can prove. The summons. Make sure you fill it out and mail it exactly as your local court has instructed you to do so, because if you send them the summons, they receive it, and still do not show up for your court date, you win by default. Now, when your case is set for a hearing, you will also be sent, in most counties, to arbitration, which means before you even go to trial, you will sit down with an arbitrator and the defendant, the people, the company you are suing, and discuss with the arbitrator what he or she feels is a fair deal. If you do not have to agree to accept the arbitrator's decision. You can still take it before the judge. When you do get in front of the judge, just tell your truth. Show your evidence, your efforts. That's all there is to it. Now, you're also going to want to have an order already written. All this is if you win, it is a legal list of what you've won, pretty much. The most important part of this entire procedure. Win or lose, celebrate. Celebrate the fact that you did this, that you accomplished this, that you stood up for yourself, that you made the effort. You did it. And remember my motto, the more you stand up for yourself, the more invincible you become. I know what you're thinking. What if I lose? What if they throw me in jail for even trying to fight back? Well, you may lose. Everybody loses at something. Once I was trying a case in front of this judge who, for whatever reason, took an instant dislike to me. So even though I had indisputable evidence, pictures, audio, emails, texts, and the other side had absolutely nothing but their word, the judge ruled in their favor. It happens. Listen, I'm not asking you to get a gun and defend yourself by shooting someone. I'm simply saying you have the strength to stand before a judge and tell your truth. You're in the right. You know you are in the right. Why let them take from you without even so much as an effort to defend yourself? You can reach me at msbryce@simplelegalfp.com.